Hi, good afternoon, everyone. I think there's still a few people joining, but we will get started. So thank you, everybody, for attending. For anyone who doesn't know, my name is Kate Benefer. I'm a partner in the Employment and Immigration team at RWK Goodman, and I'm joined today by two of my colleagues, Adrian Henderson and Sophie Waller. We're going to talk through the recent announcement, so hopefully everyone's aware. A few days ago, there was a statement of changes from the government explaining the things that are going to change for the immigration rules, which were announced in the white paper from May. So in terms of what we're going to cover, we will look at, I'm firstly going to talk you through the ending of sponsorship, so the imminent change in relation to the ending of the sponsorship route for care workers and senior care workers. I'll then talk about the in-country transitional period, so what that looks like for people who are already here. I'm then going to hand over to Adrian, who's going to talk about settlement and the increases in relation to salary. And Sophie will then talk about skill levels and some further future pending changes. We're not going to fill the full hour with us talking. There will be some time at the end for questions. Please use the Q&A box as we go along. And if you put your questions in there as we progress at the end, we will pick out as many questions as we can and try to answer those for you. There will also be some time at the end for people to put questions in at the very end of the session if you want to wait until that point. We will send out after the session a copy of the recording of the session and also a copy of the slides. So don't feel you have to write everything down. You will get the slides and the full recording afterwards. If anyone has any questions that we don't get a chance to answer in the session, you will get our contact details as well as part of that follow-up, so you can get in touch with us for more detailed inquiries. So we did run an event back in May when the white paper first came out, which went through the detail of what that white paper said in relation to various immigration changes. The changes are quite widespread, but we focused very much on your sector, so the care sector, in terms of what those changes would look like for you. The statement of changes that came out on the 2nd of July is an implementation of that white paper, or some of that white paper, and some of the changes that were set out within that. The reason that we've arranged this webinar so quickly is that the changes are going to happen very, very quickly, or some of them are. So what the white paper did was set out principles for reducing migration, ending various routes for immigration, making it much more difficult for people to be sponsored, but it didn't contain any specific details about numbers, and it didn't contain any specific details about dates. What we do now have is a date of the 22nd of July 2025, which is a couple of weeks away from now. So from that date of the 22nd of July 2025, you will no longer be able to assign a certificate of sponsorship to somebody who is outside of the UK. So somebody that needs the certificate and needs the sponsorship to move to the UK can only do so up until the 21st of July 2025 if they are being sponsored as a care worker or a senior care worker. So the two codes 6135 and 6136 are no longer going to be sponsorable for new entrants to the UK after that date. What that means in practice, we don't know over the next couple of weeks whether it will still be possible to continue to sponsor somebody. Now, if you already have a defined certificate, if you've applied for one, you've got it ready to go, and you're in the process of dealing with that, that should all be fine to go through as normal. But if you have not yet applied for a defined certificate, and we're hoping to do so over the next couple of weeks, it may be quite tight to get that through. What we've seen historically with immigration changes is that there is a set date when something is coming to an end, but in reality, in the days leading up to that date, it just becomes more and more difficult to get anything useful back from the Home Office. So if you were to request a defined certificate in the final week when these are technically still available, you may find that there's a delay and it just simply doesn't come through in time for you to process it. The individual would also need to have got their visa secured by that deadline in order to be able to move to the UK on the basis of their certificate of sponsorship being as a care worker or a senior care worker. So if you've got anybody that's in the pipeline, it's a good idea to try to expedite that. If you've got anybody you were trying to bring in from overseas, if you were thinking about potentially applying for sponsoring people overseas in the foreseeable future, you may need to look at how to adjust those plans. Now, in reality, I think for lots of organisations in the care sector, getting a defined certificate has been so difficult for such a long time that people have not been relying on it as much as perhaps they were historically. The Home Office have been notoriously difficult and scrutinised requests, asked for lots and lots of information, which has been quite difficult to provide, and therefore getting defined certificates has been something that people have put on the back burner anyway. Obviously, you've also got your displaced pool of workers that you should be working through before you assign a defined certificate at the moment. So since the 9th of April, your requirement is to go to your regional partnership, ask about whether or not there is anybody that may be already here who could take on the job. The information would then be shared with that displaced pool of workers, so individuals who came to the UK as sponsored care workers or senior care workers and have subsequently lost their job or not got enough hours because their sponsor has not been able to comply. Those individuals are given the opportunity to apply for and be considered for your roles before you can get a defined certificate anyway. So there's already been quite a process to go through before you can go for a defined certificate. And you'd still have to do that up until the 22nd of July. From the 22nd of July, that process in relation to the displaced pool will go. There will no longer be a requirement to go through that because the defined certificates will no longer be available. When the white paper came out, as well as the headline around the end to what was called the social care visa, there was also talk of a transitional arrangement and a period of time for those who are already in the UK to apply for extensions, to apply for switching, or to apply to change their employer. The white paper did provide a date. It was the only date, I think, in the whole white paper, and it talked about a date of 2028, and that has now been confirmed. So from the 22nd of July 2028 will be the end of the transitional arrangement. So what that means in practice is between now and that date, you will still be able to assign an undefined certificate of sponsorship to people who are here under some other basis. So for example, somebody who's here as a student or a graduate who wants to switch to the role of care worker or senior care worker. You will also be able to recruit people who are already here as a senior care worker or care worker working for another organisation or not working for anybody because they're currently in that displaced pool of workers and have lost their job. And you will also be able to deal with extensions. So for your existing staff who need a visa renewal, you will still be able to renew that visa and assign them a new certificate of sponsorship up until the 22nd of July 2028. Just be aware that in relation to those who want to switch, so people who are not here as a care worker or senior care worker, but for example, somebody who's a student, they can only switch under this transitional arrangement if they've worked for you for 3 months before the certificate of sponsorship is assigned to them. So the argument in the white paper and the information put forward in the statement of changes explanatory note is to say that it is there to maintain continuity of employment. So for people who already have a job carrying out the role now and have an employer-employee relationship, they can stay, they can extend, they can switch. But what you can't do is the day before the 22nd of July, employ somebody who's a student and then try to apply to give them a certificate. You wouldn't be able to do that. They would have to meet one of the other requirements to be able to join at that point. So practically, what can you do? The deadline for outside of the UK, I think in reality, that's already been so difficult for providers, it's probably not going to make a huge difference. I think people had already stopped recruiting from overseas. As I say, practically, if you were thinking you were going to try to recruit somebody, or certainly if there's an application pending or you're about to assign a certificate, suggest that everything is expedited as best you can to try to meet that 22nd of July deadline for this year. In terms of the transitional period, do bear in mind, obviously it's a way off now, but do bear in mind the 3-month rule. So if you think you might want to sponsor somebody, don't leave it till the last minute. Make sure you recruit people on different visa types at least 3 months before that July deadline. So make sure you have in mind the date when that would be the cutoff point for recruiting people on other types of visas, and just know that you won't be able to necessarily switch them over after that date. So you would only be taking them on for a very short period of time if, for example, you recruited them, in May or June. Also have a think about when you do renew your visas, when you do extend or you do recruit people, how long you assign the certificate for. I know that some organisations, for reasons of planning and cost, have been assigning certificates for a 12-month period only. There's nothing wrong with that. You can assign a certificate every 12 months and then just reassign a new one and do an extension. But just have a think about, in light of these changes, whether actually a longer assignment would be more appropriate, so that you make sure that people have got the longest visa they can possibly get, and you don't get caught by the transitional period coming to an end. I'd also suggest that you have a look at the visa expiry dates for existing staff, particularly those that are due to expire in 2028, particularly those just after the July date. So if you've got somebody, for example, whose visa is diarised to expire in August 2028, that may be the only alert that you get on your system. That alert will need to be changed so that you get an alert to flag to make sure you do something about it prior to the 22nd of July 2028, rather than waiting until the August date when it's then too late to issue a further certificate and get an extension for them. It's also worth thinking about the certificates that you have currently, so your undefined certificates that sit on your license, so your annual allocation. Obviously, I'm not suggesting you go and recruit people if you don't need them, but bear in mind, if you don't use your annual allocation, you may not get another allocation in the following year, and you may then be sort of making applications to seek further certificates of sponsorship. So if you think you're going to have a lot of recruitment, I would suggest planning that and making sure that you are using the certificates that you've got, so that you can then ensure that hopefully you get a further allocation for 2026 and then a further allocation for 2027, etc. So you have as much opportunity as possible to recruit sponsored workers without having to jump through the application process for asking for more certificates. I would anticipate, I don't know this for definite, but I would anticipate it may become more difficult to get additional certificates as we get closer to the cut-off date for the transitional period. And therefore, if you've got your annual allocation and you get that each year, that is likely to make things slightly easier. Final thing to think about from a practical point of view, just on this area, is the messaging to your staff. Now, this will all have been in the news, and there's often things that are published which are not quite correct. There's lots of misunderstandings. And the danger with this is that staff don't realise what their rights are. People could interpret this to mean I've got to leave by the 22nd of July 2025, or I've got to leave by the 22nd of July 2028, that they've got no job security. So whilst you can't make promises about they'll never be sacked and you'll always need them, it can be worth giving some reassurance to your staff so that people don't leave who have the right to stay, who could stay for longer, who you want to stay for longer. So try to sort of create a bit of calm in the workforce. It's a little bit like when we had Brexit, and organisations were offering assurances to their European staff about their right to apply for settled status. I think it's worth just making the message to your staff that you do want to keep them where you can, that you will be offering extensions to people where you can, and to give them a bit of comfort that for now, nothing is particularly changing for your existing staff. We've got another 3 years before these changes to kick in for people who are already here. So just some sort of communication to avoid people leaving who don't feel welcome or who have misunderstood the rules. So I'm going to hand over now to Adrian, who's going to talk about potential impact on settlement.
Thank you very much, Kate. So as Kate was saying, the statement of changes that was published last week did offer a helpful degree of certainty after the publication of the white paper back in March, in the sense that we do now have concrete confirmation regarding the intentions, at least, of the plans to restrict the ability of employers to issue undefined certificates of sponsorship to people before up until 2028, so the ability to do so up until that point. This then opens the door for a series of questions on other impacts relating to the employees themselves. And one of the most significant ones that comes up here is the impact on indefinite leave to remain applications. So if you have people who are in your workforce who are sponsored and who are in the UK under the impression, or have been in the UK under the impression, that they will be able to apply for indefinite leave to remain following 5 continuous years of service, that assumption has obviously been disrupted by the announcements over the last couple of months. One such announcement is the government white paper's plans to extend that qualification period from 5 years to 10 years. This has rather unhelpfully, I think, at this stage been announced without any indication of whether or not that extension of time will affect those individuals who are already in the UK and who are already working towards what until now has been assumed to be a simple 5-year qualification period. Usually with changes like this, traditionally at least, we have seen a standard really kept whereby such changes will not be will not be enforced retroactively. So, for example, last year when there was a big jump in the minimum salary levels that sponsored workers had to be paid, that did not affect individuals who were already in the UK and who already entered the system of skilled worker sponsorship before that particular change came into effect. There is nothing in the white paper that says that those people who are currently expecting that to be 5 years will be granted or have the right to apply for indefinite leave to remain after that 5-year period. And this opens up the possibility that for those people, they're simply going to have another 5 years whacked onto the end of their current 10-year, their current 5-year qualification period. Now, a lot of the sort of commentariat that has been making noises over these changes have been suggesting that it is likely that for those people already in the UK, it will be a 10-year qualification period, not a 5-year qualification period. We don't know whether that will be the case or not. I think if it will, there will be an awful lot of people making an awful lot of noise about that and trying to persuade the government not to go down that particular route. But if they do, then this means that there are people in the UK now who will not reach that 10-year qualification period, given the fact that the right to extend visas or extend certificates is being brought to an end in July 2028. So, for example, if somebody has come into the UK from, say, before July 2023, then that initial 5 years will have been built up by the date in July 2028 that the right to extend will come to an end. For them, they will be reasonably okay because their employer will be able to extend for a further 5 years before that cutoff date takes place, enabling them to get the full 10 years before an ILR application can be made. However, for anybody who has entered the UK after July 2023, by the time the cutoff date comes in July 2028, they will have acquired less than 5 years qualification period by that point, and that means that any extension, assuming that the extensions are still going to be limited to 5 years, they will be able to extend before July 2028, but not beyond that. So the majority, the most amount of time they will be able to acquire here is sort of 9 years and however many months, but not the full 10 years to reach that qualification point. So on that point, on that issue, I think what we're going to be doing is keeping our ears to the ground regarding what happens next and further announcements that come, further statements of changes that are inevitably going to be announced in the coming weeks, months, and longer, to try and get clarification on that point. In terms of how that's going to come about, we do know that there is going to be another Immigration Act that will be drafted and that will be put before Parliament in the standard primary legislative process, which will give people a little bit more notice than we've been given in this case into some of the other major changes which Sophie is going to get onto. But at the moment, there is currently significant potential implications on people intending to apply for indefinite leave to remain. Okay, next slide, please. Okay, I'm now going to hand over to Sophie, who is going to talk about salary increases.
Okay, thank you, Adrian. So in terms of salary increases, we're going to be talking about increases not only to salary, but also to the skills levels. And then also we're going to be picking up some further pending changes, which have been alluded to in the white paper. They are not yet in force, but it's useful in the context of this setting to just make everyone aware of what those are, so you yourselves can keep an eye out as these changes come through. Okay, so thinking about salary increases, the statement of changes made clear that from the 22nd of July this year, so the same deadline that Kate was talking about, the general salary threshold for skilled workers is increasing. So currently, the minimum general threshold is £38,700. That is going to increase to £41,700. Now, the key thing to note is it is a smaller increase than perhaps what we experienced last year with the increases to the rates. But it's key to note that it's going to apply to certificates of sponsorship issued after that 22nd of July deadline. Now, there are arrangements, of course, where if you're on this call, you're looking at that figure and you're thinking, well, we don't pay our care workers £38,700. There are reduced rates for care workers currently, and it's important to note that these salary increases are not going to affect sponsored care staff. They will continue to be subject to the current rates. So that is a £25,000 minimum annual salary and £12.82 per hour. So whilst that increased rate from 38 to 41 doesn't directly impact care workers and senior care workers, it's important to note because if you do sponsor other individuals within your organisation in other roles, for example, chefs or estate managers, any other kind of role, then those minimum salaries may be relevant to you. So if you are again thinking of sponsoring other roles aside from care workers, do take note, do seek advice because there are going to be further increases. Next slide, please, Kate. Okay, so in terms of the skill level as well, the key thing to know, again, from the 22nd of July, the minimum skill level is going to be increasing. So what does that mean practically? Well, at the moment, for roles to be eligible for sponsorship, they have to meet a minimum skill level of something called RQF level 3. And what that means in real terms is it's a role that is equivalent to A-level standard. Now that is increasing. So it's going from level 3 up to level 6, which is the new equivalent of a graduate level. Now, the thing to note here is that this increased skills threshold relates to the skill level of the job specifically. It is not about the qualifications that an applicant holds. So it's all about the role. It is not about that individual applicant. Now, what this has actually resulted in is this increase to the skill level is around 180 roles that are currently eligible for sponsorship. As of the 22nd of July, will no longer be eligible for sponsorship. And the key thing to note here is that care worker roles, care workers and senior care workers do not meet the minimum skills level. Now, as Kate was talking about earlier, there are transitional arrangements in place, and this is where that 2028 deadline comes in. So for anyone who is an existing sponsored worker or for someone who you sponsor before the 22nd of July this year, they can continue in a care worker role, which would be under that level 6 skills requirement, provided that their job is on the immigration salary list. And the good news for care workers is that is currently, or the temporary shortage list. The temporary shortage list is this interim temporary list that Kate was talking about. Care workers are on it currently, but there is going to be an expiry of that, and that is July 2028. Next slide, please, Kate. Okay, so some further pending changes then. The key thing to note and to caveat at the outset are that these are not yet in force. So the previous things that we've been talking about, Kate was alluding to the end of the overseas recruitment route for care workers, increases to salary and skills. That's all coming in on the 22nd of July this year. But on the slide in front of you are some things which have been alluded to in the white paper. We've spoken about them before, but they are not yet in force. So picking these up, the English language requirement. So currently, if you sponsor a skilled worker, they have to evidence their English language capability at something called level B1. And this is classified as an intermediate level. Now that is increasing to level B2. And the difference really in that classification is you go from someone with an intermediate language ability to someone who is classified as an independent user. So they'll have to meet tougher requirements on the English language. But something that's introduced for the first time is adult dependents are now also going to meet or have to meet an English language requirement. Now, for the care worker route, as we know, dependents are no longer permitted, but it will be relevant for other roles if you sponsor other roles apart from care workers. So for them, they will have to meet a certain level, A1, to enter the UK, but they will also have to show progression over time. So those dependents, those adult dependents, will have to show that their language capabilities are improving. So they'll have to show an improvement to level A2 to extend their visa, and also level B2 to settle. So that's the English language point. Another key thing to know is graduate visas. So currently, graduate visas are usually granted for a period of up to 2 years. Now, the proposal in the white paper is that they are going to reduce that to a maximum of 18 months. So it's not yet in force, as mentioned previously, but it's important to note because actually it's going to affect graduates seeking sponsorship in as a skilled worker because they're going to have a much reduced period of time by which they are permitted to stay under that route. So changes to the graduate visa. We also have the immigration skills charge. So the immigration skills charge is a charge that is payable by an employer, by a sponsor. It cannot, under any circumstances, be passed on to that migrant worker. And the cost of that is set to increase by 32%. So this is the first time that there have been increases to the immigration skills charge since it was first brought in. And practically what that means is that if you are, for example, a large sponsor and you are planning on assigning a COS to someone for 5 years, the ISE would be £5,000. For a large sponsor, it is £1,000 per year per migrant worker. But once these changes come in, that's suddenly gone from £5,000 for a large sponsor to £6,600. Now, if you sponsor many individuals, you multiply that by the number of staff, that's a substantial increase and a cost that the employer has got to bear. And then finally, picking up on the final point on the slide there. So there have been numerous mentions in the immigration white paper of Home Office compliance checks being strengthened. These innovative financial measures, penalties and sanctions. Essentially, the core aims of the white paper were to reduce net migration, improve transparency, and also build trust in the immigration system. And that's exactly what this is set out to do. For those sponsors who do not comply with the rules and do things in breach of individuals' visas and the immigration rules, there needs to be tougher sanctions, and that is the focus that the Home Office expects to be bringing in. So just to round off, further pending changes worth being aware of, but certainly not yet in force. Of course, as the position changes, and it seems to be changing very quickly, we will of course keep you updated as and when we hear things.